The legal guide to dividing assets in a Florida divorce. In Florida, the separation of assets is a critical issue for couples undergoing divorce or legal separation. Understanding the state's legal framework is essential for ensuring a fair and equitable distribution of property. Florida follows the principle of equitable distribution, which aims to divide marital assets and liabilities fairly, though not necessarily equally. Florida's Equitable Distribution Law. Florida law classifies assets and liabilities as either marital or non-marital. Marital assets include properties and debts acquired during the marriage, regardless of whose name is on the title. Non-marital assets are those acquired before the marriage or through inheritance or gift to one spouse. The distinction between marital and non-marital assets is crucial, as only marital assets are subject to equitable distribution. Several factors influence the court's decision on how to distribute marital assets equitably. These factors include the duration of the marriage, the economic circumstances of each spouse, and contributions to the marriage. Contributions can be financial, such as income and savings, or non-financial, such as homemaking and child rearing. The court also considers the desirability of retaining the marital home for the primary caregiver of the children and any intentional dissipation or waste of marital assets by either spouse. Steps in the equitable distribution process. First, both spouses must disclose their assets and liabilities fully and honestly. This disclosure is mandatory and helps ensure transparency in the distribution process. Next, the court classifies the assets and liabilities as marital or non-marital. Once classified, the court values the marital assets, which may require appraisals for properties and businesses. After valuing the assets, the court distributes them based on the principle of equity. This distribution can result in one spouse receiving a larger share of certain assets, such as the family home, while the other spouse may receive a greater portion of liquid assets, like savings or retirement accounts. The goal is to ensure that each spouse receives a fair share, considering their contributions and future needs. Special considerations in Florida. Florida's approach to asset distribution includes some special considerations. For instance, prenuptial and postnuptial agreements can significantly impact the distribution process. These agreements, if valid, outline how assets and liabilities should be divided in the event of a divorce. Additionally, Florida courts may consider alimony awards when distributing assets, ensuring that one spouse does not receive a disproportionate financial burden. Moreover, businesses owned by one or both spouses can complicate the distribution process. The court may need to determine the value of the business and decide whether it should be sold, one spouse should buy out the other's interest, or it should continue to be co-owned. Conclusion: navigating the separation of assets in Florida requires a thorough understanding of the state's equitable distribution laws. Couples should seek legal advice to ensure their interests are protected and to achieve a fair distribution of marital assets. Watch more videos like this in the associated playlist or the recommended video in the description of the video you just watched.